So let's say a court has determined a visitation schedule. If the parties have either agreed to it or the court has had to set it, but then it's not working out so well.
Right.
What remedies does the aggrieved spouse have if the other spouse didn't deliver the child at the appointed time? And is that a large component of the post-decree practice?
Oh, it's huge.
Going back to court to...
Well, and mediation and collaborative law, I'm going to take you back to that quickly because, first of all, mediation is not arbitration, number one. People need to know that. Arbitration is when you go to an individual and that individual makes a decision for you, which is basically court.
Right.
So you're just not in a courtroom,
Right.
basically court. Mediation, the parties come to their own decision. Parties can choose to mediate, never see a courtroom, and then choose to mediate again. Don't have to see a courtroom, don't have to file a motion. You can say, I want to mediate this issue. More than likely, counsel is going to file a motion to modify the schedule. And again, Scott, anytime I go into court, I have to meet the statutory criteria before I walk in the door. So if I'm going to modify a parenting agreement, why am I modifying it? Does it make sense? Am I doing it just to indulge my client, which I'm never going to do if they're going to lose? Why would I do that? I'm a straight shooter about what I think the chances are when they go into court. And if I think they're going to lose, I'm not going to take the case. Why would I do that? I think it's just silly, and it's more emotionally draining for the client. So if you're going to modify a schedule, it has to be that it doesn't work, and not that it doesn't work for you. It has to be that it doesn't work for the child, and what can you show me to show me that this isn't working for this kid? Is a kid anxious? Most kids are anxious. So what is the different anxiety than it was before? How is the anxiety amped up? Or, is the child wetting the bed? Is the child having nightmares? Something big, something large enough in the child's life and the child's psychology, and something that would make the court change the parenting schedule. And one of the big ones would be if one of the parents is going to move. You would go to court. There's a relocation form that's in the AOC forms that one has to fill out now, and that's a change in the law too, because it used to be it just went back to WIC, and now you actually have to fill out a form. You do a motion to relocate. You have to prove it's in the best interest of the child to relocate if the other parent objects. So that's a huge modification of a parenting agreement, and that could be a case that you actually go to court, along with what school is the child going to attend, huge, that people can't agree on. And the courts, of course, can't order private school, but the parties can talk about that during mediation as well. But you have to meet the statutory criteria if you're going to modify a parenting schedule, and I'm not doing it for the parents. I'm not doing it because somebody got married. I'm not doing it because somebody has a different job. I might. Their work hours change dramatically. So there are reasons to do it that are related to the parents' needs, but mostly it's going to be what's going on with the kid.
Okay.